Mistake number 9 is tangible personal property. Did you know that it's something like 75% of all state litigation revolves around the handling of tangible personal property, which is stupid. Because that is the least valuable asset often in the estate. Now, if we're talking about Van Goghs and Picassos, no, that's important. Or collectibles or antiques. Family heirlooms are more personal items that may not have real value. Photos, the same thing. Jewelry, artwork, collectibles. All that stuff is what people remember because they see it. It's tangible. They don't see the financial account that has $5 million in it. They see the diamond ring that mom had that dad gave her that was a 2-carat that might be worth $30,000. But they fixate on that. So how do you deal with that? Very simple. Have a personal property memorandum that flows and is attached to your irrevocable living trust. And so if you transfer all your personal property into your irrevocable living trust, and then the assets flow under the trust, and you refer in your trust to a personal property memorandum, you can do changes to that memorandum at any time. And in the memorandum, you'll say, I give my 14-carat yellow gold, 3-carat white diamond ring to Jody, and that should take care of it without having to include it in a will or codicil to a will. David?
Not that I've ever seen this happen, but as a practical matter, with personal property, how often does that get included in the inventory of the estate?
We do a lot of estate administration work here. Probably our small group does 50 to 55 estates at any given time we're open. The Commissioner of Accounts in Fairfax County and Loudoun County and Arlington County look for it. So they are looking for it on the inventory. Now, what are they looking for? They're looking for an accounting. If there was nothing of real value, then it could be a single line item.
But how often do you get detail? Because you might say, well, all my personal property is worth $100,000.
If it's, I can tell you that if it's over $10,000 or $15,000, if there's not a specific accounting for it, the Commissioner of Accounts in our great state of Virginia will ask for that.
Okay.
In Montgomery County, it's a little different because there's a less formal process. There's an informal modified administration process. And if everything's being left to a spouse, nothing is ever asked for. If everything's being left to kids, usually nothing is asked for. But it's usually the kids that create the problems.
Oh, sure.
And so if you don't account for it, the one who's not acting as the executor or the personal representative or the trustee is the one who always raises the problems. I'm involved in 2 estate litigation matters right now. It shouldn't be in litigation, but the kids are just, they hate each other. They hate each other. They don't trust each other. She stole the piece of art that was sitting in the living room. It might be worth $50. I don't know. It's a big deal. And then they start seeing the legal bills come in, and then they get
Family
back.
homes. They come in and take it for it.
Exactly. I've seen that happen too.
Right. How many times have you seen someone come in and say, my aunt promised me that brooch. Oh, my aunt promised me that brooch. And, prompt them to go.
Prove it.
Yeah.
Prove it. That's what the personal property memorandum does. It doesn't have to be in the will. It doesn't have to be in the trust. The memorandum is a signed document. But as long as it's signed and dated in Virginia, it's enforceable, even without the trust, even without a will. Virginia's got a statute that's very progressive in that regard. In Maryland and DC, no. You've got to have some mechanism through which the personal property would pass. Number 10 is a big one. Spouses and kids, particularly when we're dealing with second marriages. And with the divorce rate at an average of 50%, of every person between the ages of 18 and 55 have been divorced at least once in the United States. That's a significant issue. And there may be kids from the first marriage, there may be kids from the second marriage, there may be blended family issues. How do you plan for that without offending somebody? And it becomes very sensitive, very touchy in the planning process. Common thing I've seen over and over again, surviving spouse is victimized by an unscrupulous second or third spouse who comes in and convinces the surviving spouse, who's in control of the estate, to pull the assets out and put them in a joint account, or buy a house in joint name, or whatever. By building a trust to protect the surviving spouse from herself or himself, it may be a useful technique. Spouse gets sued, runs over somebody in a car, doesn't have adequate auto insurance or umbrella insurance, or punches somebody out in the bar. There's not enough insurance for it. What do? The lawsuit could basically wipe out the estate unless it's properly structured in trust. If the surviving spouse is the sole trustee and that lawsuit comes, the creditor is going to have a much easier window, much easier way of getting access to those assets. My job is to make sure that they're aware of the downsides of things that can happen. That's what lawyers focus on, the risks. How do we mitigate the risks? Most of our clients say, it's never going to happen. Don't worry about it. I don't want to talk about that. She'll do the right thing. That's fine. My job is to make sure that they're aware of what could happen. And we've experienced it. We've seen it. And then the surviving spouse, I have a client coming in today, right after we're done here, to talk about estate administration. It was a second marriage for both. The husband passed away. He left all of his assets to his surviving spouse. He has 4 kids from his first marriage. He cut him out. And he did that intentionally. I don't know why. That was his wish. You can do anything you want in your estate planning documents. It's just what are the ramifications of what you're doing. You have to think about it. So building a trust with protections. A co-trustee who the spouse must go to for distribution decisions is an often very good protection. But if the spouse has the right to replace that trustee with anyone she wants to or he wants to, that may not be protection. These are all things that we talk about in the estate planning consultation when we're going through all the details. Number 11, children don't need inheritance protection. I don't need to rule from the grave. Wrong. I think kids need protection against themselves and potential creditors. Again, this is up to the client. The client will tell me, you'll tell me about your kids. I want to know about them, how they're doing in life. If they're all professionals making a very successful living and know how to manage assets and they're good at what they do, and I have many clients who are in that, I'd say a minority of clients who are in that situation, but I have clients who are in that situation where their kids have grown up to be extraordinary, talented, successful individuals. God bless them. Then there are the rest of us who have some kids that are really talented and successful and some kids who didn't quite end up that way. It's the nature of evolution and DNA and bad parenting. I don't know. But the idea is that they may need inheritance protection. I have one client that has 2 children who are mentally disabled. Let's just put it that way. And one child is functioning at a very high level, doing very well. They didn't want the 3 kids to be differentiated in their documents. So we imposed a general standard that the assets are to remain in trust with independent trustees managing the assets for the kids until they're much, much, much older, 50. But they wrote a letter to the trustees expressing what their wishes were with respect to each of the 3 kids, talking about each of the 3 kids and what their deficiencies are or sufficiencies are. And that is how they're managing their estate, which I thought was a really good way of handling it. So the trustees know that with one of the kids, they can be a lot more liberal than the other 2.
How did they choose the trustees?
In their case, they had family members that they could trust. But a lot of us don't have family members that we can trust or feel comfortable appointing. A lot of us do. We're fortunate in that way. Again, the trustee successor manual gets into that in great detail. We just don't want our kids to become filthy rich at the age of 18 or 21 or trust fund babies where they're standing there with their hands out waiting for a handout from the trustee. there is an obligation when they become of age that they be notified of the existence of the trust, and they actually have the right to demand accountings in Maryland, DC, and Virginia. So they can get it, but they may not be able to get at the assets if you draft the trust properly. So inheritance protection, you might put the kid in as a co-trustee, but they have to get permission from the other co-trustee to get distributions. When they hit a certain age, when they're old enough, or they've proven to you or your clients that they are able to manage their affairs well enough, they might be able to withdraw it. Health, education, maintenance, and support, by the way, is an extremely broad standard. And if you impose that standard in a trust without putting any parameters around it, that gives them the right to basically ask for a lot of stuff that you may not have contemplated. So putting guidelines in the trust, defining what health, education, maintenance, and support is well advised. And if you don't even want to go there, a less liberal standard, a more rigorous standard, is to impose just a discretionary trust, where the trustee has total discretion whether or not to make any distributions. That gives greater creditor protection, greater asset protection, greater protection from themselves. Mistake number 12, and this is a big one. Some of you in here actually work with psychologists, sociologists who can work with families who have exceptional wealth to design family values. What are family values? Well, estate planning is not just about transferring assets or saving taxes or avoiding costs. It's about figuring out what the family's mission is. And if we're dealing with higher net worth clients, it's good to sit down with the family and try to define really what the goal of all this wealth is. Now, I have some clients that say, up to X dollars, my kids will get it. Over that, it goes to charity. Fine. But what about the X dollars, which might be 5 million, it might be 10 million, it might be 20 million, it might be 100 million. What is your mission for your kids? What are the values that you're trying to impart? Are they religious? Are they scholastic? Are they eleemosynary, charitable? What are your goals for your kids? So establishing that family mission statement is important. We do that a lot with clients, and we also conduct family meetings where we'll sit down. I have a client who yesterday asked, is it okay if I bring in my kids next year after we've sort of gotten this thing underway? And we sit down with them and describe what we just did and how it works and why. Yeah, do that a lot. It's very successful. Depending. There's some kids who look at it as, it's mine. We have a client like that. It's mine. I'm entitled to it. What do you mean I can't get it? It's in trust. Well, that's what I mean. That's what your parents want. It's not ruling from the grave. It's protecting you for the future. It might actually provide you with retirement assets because you haven't been able to accumulate them during your lifetime. It's harder for our kids to make a living today in general. So this is a list. It's the scorecard. It's the top 12 mistakes that we want our clients to avoid. Our job is to help with the estate planning. We'll give you and your clients a range of fees depending on what it is that we have to do for you. We'll actually do it for a fixed fee. We prefer that because the client prefers it. We know that clients don't like meters running unless it's undefined. And if it's undefined, then we bill by the hour. Most estate planners bill by the hour anyway. We found that the fixed fee arrangement works really well. And we'll give free consultations. If you refer us a client, you won't do it because you're here and you're learning and you're participating in this. And we'll give free consultations. Sometimes they last a half hour, sometimes they last an hour, depending on what the client wants to learn. We'll educate them in that initial consultation. And then they'll come back 99 times out of